The Supreme Court weighs in on the question of whether or not the Census Bureau can ask, "Are you a citizen in the census?" A confusing decision appears to remand the case back to the lower courts. The ultimate resolution isn't clear, but a couple things do become clear reading this decision. And here to tell us what they are, Chris Hajec, Counsel, Director of Litigation with the Immigration Reform Law Institute. Thanks for joining us. Okay, bottom line, what did we decide today? Long decision, a lot of alternative views and dissents.
But it all hinged on Chief Justice Roberts' view of one particular issue. And that was because the Chief Justice and the majority upheld the entire census question. They said, we're not finding it substantively invalid. We just don't think there was enough reasoned decision-making here because Secretary Ross had some other unknown motive for putting it on. It wasn't just to help enforce the Voting Rights Act, as he said. But they didn't know what that motive was. Historically, the court has always said that doesn't matter. You can have other motives. We don't look into motives. One of the motives might be the president told him to do it.
So, the point is, I don't even know my own motives half the time. I can't tell what your motives are, right?
Right. And when you get into, the law that they've decided this under just demands that you give good reasons. You explain yourself sufficiently so it makes sense. The decision you've made makes sense under the applicable statute. And, the court found he did that, but that was just contrived.
So taking through the reasoning, and again, it's just complicated stuff, and I don't mean to discourage you from following our train of thought here, but there's like 3 or 4 different opinions that have been filed. But the overarching framework of this is simple. Congress delegated broad authority to the Department of Commerce to carry out the census for the purpose of enumerating people for reapportioning congressional districts. How the census is carried out is a general delegation by Congress to the Department of Commerce, correct?
Yes.
And the census statute doesn't provide a whole lot of specific guidance on how it ought to be carried out. So courts interpreting that statute would say Census Bureau has a lot of discretion in how to carry it out, right? What questions asked? They ask all kinds of questions. How many TVs do you have? How many toilets do you have? How many pets do you have? Did you have diarrhea last month? All kinds of questions for all sorts of commercial and other empirical purposes. Right?
Yes.
Then there's the Administrative Procedure Act, which is supposed to govern how agencies make decisions under broad statutory delegations, right?
Right.
The court said the Administrative Procedure Act didn't apply in this case. There wasn't a violation of the Administrative Procedure Act. Right?
The court found no specific violation of the Administrative Procedure Act.
So the APA is not the issue in the majority opinion.
Well, apparently it added a new section to the APA, which doesn't have authority to do, that
they didn't find an explicit APA violation in the majority opinion.
No, they didn't.
All right, so there's no APA violation, no Administrative Procedure Act violation. So what we're actually looking at is the reasoning of the Census Bureau under the broad delegation of the census statute.
It said that was okay.
So that was okay because it's broad.
Yeah.
So then at the very end they said,
the Census Act.
So at the very end they sort of meandered around in this incoherent ramble. They said, well, internally inconsistent reasoning?
Yes, what they said was normally, and this is what I've focused on this on the brief we wrote to the court, and the 4 conservatives on the court agreed with it and disagreed with Roberts. But he said normally the fact that an agency head has other motives that you don't know about, and you don't know if they're improper, there's no evidence that they are improper, doesn't matter. We don't have a general rule against pretexts as reasons. But here, looking at the evidence here, it appears that the reason given was, contrived. Well, pretexts are always contrived. If pretexts are okay, usually, why is a contrived pretext not okay? It's just babbling nonsense.
And therefore, the court just said, we want to send the case back with instructions to figure out if there's actually a good reason to do this.
Well, yeah.
We are a nation. We have citizens. Citizenship is kind of a fundamental office in a democracy.
Yes.
We're either a citizen or we're not a citizen.
Yes.
It's binary, right?
Yes.
Why would it be impermissible to ask, are you a citizen?
It's not. And the court
when you're
didn't-
asking how many toilets you have, how many TVs you have, how many, did you vote last time?
Look,
where do
let me
you
tell you,
normally sleep? Don't they ask you where you normally sleep?
Yeah, let me tell you.
I mean, come on.
When people hear about this decision, they just hear what the decision was, that basically
So
stops
basically
Trump from
the-
asking the
right.
citizenship question. They're going to think that's completely bizarre.
I mean, we're at the
And it
point
is.
now, we're 2.5 years into this administration, the judiciary has simply taken over running the executive. Wouldn't you say at this point?
This is
Congress
one of those,
having
this is one of those,
abdicated its authority to govern, the courts are basically running the government.
This is one of those Trump can't govern decisions. What's disappointing is that it comes from the Supreme Court. Previously, they've just come from rogue district courts and bad circuit courts that are now getting somewhat better. But for Roberts to do this is disturbing. But the main reason, from the standpoint of our movement, that we wanted a citizenship question is that it makes it easier for Trump, if he wanted to do so, to exclude illegal aliens from the census for apportionment purposes.
Sure, it makes it easier, but even more importantly than that, Chris, I want to know how much immigration is costing me in this school district, in my hospitals, in my state.
Yeah.
That's what I want to know.
Yeah.
I want to know the cost of immigration. How do you find out better than by specifically delineating the percentage or the number of non-citizens in any area of the country? I mean, this is a no-brainer. The broad public policy interest in having this information is critical for a whole range of reasons, including enforcing the Voting Rights Act. So what on earth does the lower court do with this incoherent guidance? I mean, you could say they're punting, but then you have this Judge Furman, who's basically going to say, aha.
Yes, I'm
I agree
completely
it's
vindicated.
protectual. So what does he do? Does he
He,
resolve it? Then it gets appealed again, right?
Well, he can let the agency come up with its real reason. Supposedly didn't give its real reason. So it comes up with the reason you just suggested. And what does Furman do? He says, you never mentioned this before. This is just another contrived pretext. You never talked about looking into the costs of immigration or anything else. You just talked about the Voting Rights Act. And
So why couldn't the court do this with any question by the census?
now the well is poisoned. I mean, anything Ross says now is going to be considered contrived, and I don't know how you fix that. That's another big problem with having a rule against pretext in general.
Well, what happens if Ross just runs a census anyway with the question?
If he's been enjoined from doing so.
Did they issue an injunction?
Well, he would have to. If he tried that, they'd take him back to court to get an injunction.
Did they uphold the injunction?
And it would be upheld.
Did the court today uphold the injunction?
It wasn't an injunction; it was a remand to the agency. That's what.
So it went back to
Furman
the
did.
agency for what purpose? To reconsider the rationale?
Yeah, basically, there's not enough time really to do that.
They
And
can
for the
probably cook
reasons
up something in the next week.
Yeah, but
They
if
have
it's
till
cooked up,
October.
he'll just say it's another pretext.
So what? You got to give it a shot.
Maybe they will.
So what I guess I really don't understand about this whole thing is how did the plaintiffs get standing? The allegation that including a census question would lead to an undercount, meaning people who live here illegally, violate the law, have no right to be here, might be concerned about filling out an official government document. Not sure where the evidence of that is. But isn't that what we lawyers call speculative?
Yes, they didn't find. It is kind of speculative. Yes.
Right. I mean, when we have been bounced out on standing, challenging census practices,
And-
we've always been told, right, that you can't prove to a certainty you're going to be injured and therefore going to be rectified. And
Right,
you're going to be made whole by the relief you're requesting.
Well,
The relief being requested cannot guarantee that the undercount asserted is not going to happen, and therefore it's entirely speculative injury, right?
Yeah. Well, Alabama is right now challenging the Census Bureau and moving for a ruling that they can't count illegal aliens in the census for apportionment purposes. They showed to the satisfaction of the district court in Alabama that they would be injured by their inclusion in the apportionment
Right,
count.
and it only took
they'd
40
lose
years, 40 years to get a
lose a
district
seat.
court to recognize that.
But New York's problem is even worse. They have to show that it's more than just speculative, that asking the question will reduce participation by illegal aliens or other non-citizens. And as the court noted in its opinion, there's really not much evidence for that. And the fact is that non-citizens tend generally not to participate in the census. They don't want to, whether they're asked about citizenship or not.
So there's no injury, therefore no standing. It's all speculative. Why were they even able to bring the case?
Well,
I mean, I'm asking these questions because I want you all to understand the subjective nature by which our judiciary is now intruding itself in what are ultimately political questions that are of no business, frankly, in the judicial framework. This is a total inappropriate exercise of judicial authority and something that has been clearly delegated to Congress for the Department of Commerce to carry out every 10 years. The politicization of the judiciary has gotten out of control.
Yes, and and the very form this decision took. I mean, so far until this decision, the court's been respectful of presidential authority over the executive branch. I mean, he could direct regulatory policy. He could tell agencies what to do, and they'd come up with reasons. And the court would say, that's reasoned decision-making, that's fine. That's all the APA requires. Now they're saying, well, no, the president can't tell you what to do when the reason you come up with is contrived. It's always to some extent contrived.
Sure.
And so what they're doing, the only way the people have a power over the heads of agencies who aren't elected is through the president. So the only way we have power over them is if he has power over them. And this decision reduced that power.
All right, well, I encourage you to read the decision. It takes a little while because there's a number of different concurring opinions and a dissent. But Justice Roberts has once again come through for the liberal side of the court and demonstrated for various reasons that he's not a reliable voice when it comes to statutory construction and traditional interpretations of congressional delegations of authority to agencies. So with that, I will tell you thanks for watching and thanks for listening. I'm here with Chris Hajec, and there'll be more information about this case on our website. Thanks for watching.